Njui has is on board now, and he has requested that he wants to understand exactly what are some of your expectations, or what are some of your questions that you'd want him to address. So you can either speak out, or you can either just type them in the chat, then we'll attend to them as we move. So I want to maybe for 5 minutes open up the floor so that anybody who thinks they want to share with us the expectations can freely do so. Is that in order? I can see, Mike, you are now the host. So you may unmute the people, and once you are unmuted, please ensure you mute yourself and only unmute when you want to speak. That will make it better for us to interact. Anne Kariuki, are you here? Anne? Eda? I can see Jane Wanjoy is here, welcome. And we continue to pray for you and to wish you the best as you go about perhaps the most difficult time. Anybody who wants to share with us what the expectations are? Can we allow Mr. Kinyanjui to take the floor?
Yes, I think so.
Mr. Kinyanjui, can you hear me?
Yes, I can hear you, Paul.
I think we'll have to interact with the listeners as you speak. There is the chat option, which I'm sure many will want to utilize. In the interest of time, I want to welcome you to take us off so that we are able to finish off before 5.
Well, let me then share the slides. You can view my screen from your end?
Yes, yes, we can.
Well, then, perhaps also as a preliminary, we wish then to request one from your end if you can pick in any questions that may come into the text. And then
yes, I will.
You bounce it to me at an appropriate time. Otherwise, for the team, good afternoon. As introduced, my name is Kinyanjui. You know, I have interacted with you on quite a number of sessions. And today, my task was to just take you through industrial relations, some aspect of grievance handling. Mostly, I will, in doing so, highlight the legal framework that governs industrial relations in Kenya. And as we go ahead, I will look at some few practical situations. And then towards the end, I'll be glad to receive any questions from your end. And as it is well understood generally, when you're talking about IR, we are talking about relationships at workplace. And we are very well aware that this is actually core, because without industrial relations, you really find that no players in employment relationship achieve their objectives. And therefore, it always has to bring in players who include the workers, the employers, and the government, more or commonly or collectively referred to as the tripartite players. And each of the parties at every one time to ensure that they carry out their role, they carry out their role in a complementing way, so that any issue that could end up being or getting out of hand can be addressed within the laid down mechanism. It is also important to note that having this kind of agreements or this kind of tripartite players also informs other collateral players in industrial relations that may include the employment court, which any other time, whenever there is a disagreement, any of the players may result into going to the same courts for interpretation. And critical or key in these institutions resolving this dispute is more on whether each of the players did their roles as required by the document that we'll be looking at shortly, and this is the Industrial Relations Charter. I know most of us have interacted with this document, and it is quite a document that is pre-independence, and it was more about trade unions, the employers associations, or the federation, and the government basically coming together, agreeing that they need to work together in a workplace environment, and therefore came up with more or less an industrial relations charter, which is more or less the MOU that guides how each of these parties to exercise their mandate without overlapping or with as little friction as possible. Now, the parties in the current circumstances were drawn from the Confederation of Trade Unions. This is on behalf of all trade unions in Kenya. The Federation of Kenya Employers, again coming in on behalf of both the individual and employers association, and in this case representing employers' interests. And of course, the government through the Ministry of Labor, as it was then, of course, and it comes with the ministry changes in terms of its portfolio, but our key input here is that it is a ministry at one time in charge of labor. And what we need to look at basically, because this is usually the mother of all these other documents that we will talk about later, whether the CBAs, whether the recognition agreements, and so on and so forth, they all gain root from this document that is a wider framework that is now later on customized to individual work setup. And the key provisions of the charter captures an agreement between the three players. And if you look at these key provisions, they should also guide us as HR players, because sometimes we find ourselves just pulling on one side. If you just present capital, you find that sometimes you are ready to do what capital or what the interest of capital, and by extension you end up stepping on the toes of maybe other players to the employment relationship, being those who represent labor. So the key is that settlement of differences disputes and grievances is through mutual negotiations, conciliations, and voluntary arbitration. So the first tenet there is that the players under the Industrial Relations Charter are avoiding a scenario of chest dumping, are avoiding a scenario of the winner take it all, are avoiding a scenario where one party fails to recognize the role of the other. Sorted through mutual. And once again, mutual means you have to accommodate the other side. You have to listen to the interests of the employer, and you have to listen to the interests of the union. And by extension, you also have to appreciate that at every one time that the government also has an interest in the employment relationship. And this is to be done within the laid down procedures. And these procedures have been widely repeated in recognition agreements. They have been highly cited in employment courts in cases of disputes. And therefore, the procedures that you put in place must be founded on the principle of mutual negotiations and recognition of each other's other parties' rights. You also realize by the time parties were coming together to put in the Industrial Relations Charter, one subject that touches all of the three parties is the issue of strike. And by saying this, strikes, lockouts, or whichever other way they manifest themselves, you realize of late the unions have been resorting to Oslo's, others they call it peaceful demonstration. Whatever you call it, I just want to stick to a strike where we are referring to withdrawal of labor. Obviously, this has a bearing on the employees, has a bearing on the employer, has a bearing on the government. And therefore, the parties were able to come together, and while appreciating that the employees have a right to strike, then this right has to be in line with the mutual, what we said, mutual agreement, that has to be a structure that an employee or employees will not just wake up and sit down. And this is where latter provisions, whether in the trade dispute, which as it was then and now currently the Labor Relations Act, this borrows heavily that there has to be a procedure before a strike is called upon. With our current or many industries, we realize this is what brings in issues of that before a strike notice, there has to be dialogue. And if parties to a recognition agreement are not able to agree at the bipartite level, then most of our recognition agreement, and I will be glad to hear your peculiar circumstances, will provide that if you as the employer and the employees or the representatives fail to agree at the employment level or at the shop floor level, then the next recourse would be to take it to the Ministry of Labor as a dispute. And it is only then, after that dispute is not resolved amicably, that parties can now proceed or resort to a strike situation. There are so many other conditions about who can issue a strike notice. The agreed principle in most recognition agreement is that the responsibility for calling for a strike vests in the highest executive of the trade union, and in this case, the Secretary Generals. And therefore, if, for instance, the strike is called by any other person, it will be void. There has been also a lot that has been borrowed from this, including from many court cases that have clearly indicated that even in case of a strike, that employees are still expected to be bound by the rules and regulations of the company. They are still expected to be full. They are still expected to be at their place of work, because otherwise it negates the purpose of a strike, which means that if, for instance, the issue in dispute is resolved, employees should be able to return to work immediately. There is so many other provisions regarding to how a strike action should be, including exemption of some class of employees from engaging in a strike action. And these are the category of employees that are referred to as essential services. And again, just to understand why it is important to have each party understand the other, is that, like, for instance, when parties come up with an agreement about essential services, both at the national level, because remember the government, the largest employer, or even at the bipartite between the employer and employee, it is understood first, even before you go to the right to strike under the Constitution or under the Labor Relations Act. It is first understood that the purpose of a strike is not to kill business. And therefore, parties in the spirit of Industrial Relations Charter have to agree that some aspect of labor can be withdrawn, because, like you said again, the intent of a strike is to push or put pressure on an employer to agree some demands of the union, of course, within reason, and not to paralyze or not to kill, because it negates the purpose. Because after the strike has been resolved, then if every employee, including those carrying out very essential services, would have also been on strike, then you may realize the company may have already gone under. These, in many situations, would include persons working in security, persons working in health. In the government, if you look at the Labor Relations Act, you include those in the ferry services and so on. Here we are saying those employees who at all one time to ensure security and health cannot and should not be in a strike situation. Again, that has been captured under that key principle of the Industrial Relations Charter. Key is that provision is also that recognition agreements must also have a grievance handling procedure. And key principle in a good recognition agreement is to provide for speedy resolution of the grievance leading to a settlement. And of course, there has to be an aspect of fairness, meaning there has to be full investigation. None of the party will be hasty in coming up with a drastic situation. And remember, here we are talking about collective kind of grievances as opposed to individual. That which has the potential of blowing out into industrial unrest. And therefore, again, once you assess the provisions of your recognition agreement, if you're in a union setup, then you will see that this is key. And if you don't have a union, the same should guide, because grievances will arise whether within the setup of a recognition agreement, I mean the setup of a CBA environment, or outside. And that is key, full investigation and speedy resolution that will lead to a settlement. If there was, under the Industrial Relations Charter, the push to establish a national joint consultative council. Unfortunately, some of these staff, which were very good recommendations, have never been fully implemented. But in this case, this was a specialized body that would have been drawn from different, from these players to the Industrial Relations Charter. And their duty would have been to advise the Minister of Labor on general industrial relations in the country. It has been submission of many players, that the existence of such a tripartite body would have been key in advising parties, including the government itself. As we are aware, it has been a victim of quite a number of industrial unrest. But then the way they were being dealt with, sometimes you could hear people doubting the advisory offered to the Ministry of Labor, given that sometimes they may not be, they would be relying on technical kind of advice from a body like National Joint Consultative Council had it been in place. And the tripartitism, whenever you have the employers, employees, maybe under a dispute or something, would obviously be chaired, as it is always the case, by the ministry, who at any one time is in charge. But then it will also bring in more players, because it is one thing to overstrike, but you realize if you're the Minister of Labor and the doctors, for instance, are asking for this kind of an increment, then you realize other ministries, starting with finance and others who might follow queue, would equally be required in such consultative meetings, so that we avoid a situation where at one point you just sign a return to work formula and you promise what many years will not have been implemented. And this has been something that has been playing out in public, especially in civil service, where for the purpose of ending a strike, you just sign, but then later on you find the Salaries and Remuneration Commission come in and say, no, at all times these are civil servants, you cannot have a section of employees of the government being paid higher than others simply because of the strike action. So as you're saying, it has to, the intention here was very noble, so that you're bringing in all the players that have a bearing or have an input in the solution of an employment dispute, and ensure that you get agreements that are sustainable. Another issue which has been quite pertinent, and again, I would wish to hear your input on the same. There has been an issue of, on one side, the Constitution provides that every worker has a right to join a union, and that is under the Article 41 of the Constitution of Kenya. And this is an argument that has been quite popular with trade unions, because in this case, they will be saying everyone in your company, your industry can, and indeed is eligible to join a union to the extent that they are workers in the meaning of Article 41. But, and this gained root very fast when the new constitution was promulgated, because initially these rights were statutory rights, as opposed to now when they are constitutional rights. So being statutory rights means then they were limited by the statutes, they were limited by other regulations, and other, like for instance, this document, the Industrial Relations Charter, that was very clear in terms of who can the union represent and who can they not represent. And I need to emphasize this. It is not more so about what a person does. Like for instance, it is not a question of if maybe in a company you have employed a doctor or you have even employed a pilot. It is not a question of whether pilots should join. It's not a question of whether doctors join the union. And you know they have joined pursuant to that. It is a question of if you are coming in an employment setup, where do we draw a line between those persons who will be talking on behalf of management? Because this is bargaining. Most of the time, an employer is a legal person, is an abstract person, which in this case means that this company cannot speak for itself. Somebody has to speak for itself. This company does not do its own finances. It's done through a person employed to do that. So there has to be some category of employees who would be deemed to be representing the employer and therefore not eligible to join the union. And under Appendix 6 of the Industrial Relations Charter, if, for instance, you are an executive chairman, you are an MD, you are a GM or the deputy to the GM, you are a departmental head or a deputy, then in this case, it was so clear. It was agreed between the union employers and the government that those ones should not join a union. If you're talking about branch managers, again, under the Industrial Relations Charter, again, you cannot join a union. Look at other categories other than the titles in terms of the branch managers or the MDs and all that. You'll also be looking at what someone does, not more so about your title, because different titles manifest differently in different organizations. It's more about, are you in charge of operations in a certain area? So if you can say you have been tasked by the employer to be in charge of operations in area A, you and your deputy should not be eligible to join the union. Therefore, you cannot be represented by the union that negotiates with your employer. And again, I will need to emphasize, you could join a union, but not this union that has been recognized by your employer. Because the union that has been recognized by your employer only negotiates on behalf of those persons who are not deemed to be managers. But for instance, you could have a doctor who is employed in a certain company, maybe a company that runs a clinic, and this doctor decides to join another because you realize at the moment now you have what we are calling initially unions who are registered in sectors. And therefore it has to be the agricultural sector, the banking sector, textile. If you look at the general wages orders of the wages or all those the sectors as they are categorized under the general wages order. I mean, not general, because the same is borrowed from the Act, which then was the Regulation of Wages and Condition of Employment Act. If you look at the schedules to all those orders that from all orders other than general, which so to speak is general, all of them are in terms of sectors: the hotel sectors, the education sectors, textile sector, education sector, and all, so on and so forth. But with the time, you have found unions that have come up that represents trades or that represent professions, like for instance, the nurses union, the doctors union, and so on and so forth, which in the current circumstances now graze that sectoral area, because you could have a doctor who is necessarily not in the medical sector, but maybe is employed in a flower farm, which is in the agricultural sector. Where we have to emphasize on that is that as an employee, you may not have a right to stop this nurse from joining that nurse's union. But clearly, if you're negotiating, for instance, in the agricultural sector, you are representing in the agricultural sector with a union like the Kenya Plantation and Agricultural Workers Union, then clearly the plantation union has only mandate to represent unionizable employees in the agricultural sector and cannot purport to represent a doctor and so on and so forth. So, the one that I would also want us to emphasize is that it is the employer that recognizes the union. And therefore, it is the employer that gives the conditions upon which you are representing a union. In this case, you set up those conditions, including the cadres of the employees that you'd wish that they be under this union to negotiate their wages and other terms as it may come. If you feel some categories are beyond or should be on the other side of the management, then this should be discussed and agreed upon at the recognition agreement level. and again. And this is something that has again played out in so many disputes. Whenever there is a dispute about whether someone is a manager. And in this case, I would want to use a practical case of a level we mostly refer and identify with as supervisors. We have had companies that have just put a sweeping clause that supervisors are not unionizable. And we have had so many cases where the union has taken this issue to court. And how that dispute has always played out is not about the fact that this person has a contract of a supervisor. It has always shaped up in what does this person do? It does not manifest in the title. The title could be a manager, could be a foreman, could be a team leader, could be, name them. I'm sure you have to be a quality controller and so on and so forth. But for determination of a dispute, whether the person in question is a manager or is non-unionizable, then the labor conciliator or the court will look at his JD, and from clause 4, what is the authority? Can they hire or recommend at a high level the hiring of who becomes an employee? Do they have powers to transfer, suspend, appraise performance? Can they promote? Can they reward? Can they discipline? Can they handle grievances? Yeah. In the event that this person with the sole title given to them have powers and authorities and the functions in their job descriptions to carry out any of these, then irrespective of the titles, they are managers. And the flip of it is true. Even if you call them a supervisor and you realize they have absolutely no authority to do any of the managerial functions, then they are unionizable, and any attempt to remove them from the organization will flop. So once again, it is key. That's not about the title. It's about what this person does. And remember, the union usually represents the cadre of employees we refer to as unionizable. And I hope you do not confuse that with unionized, because interchangeably we'll be using the unionizable, non-unionizable, and the unionized. So unionizable means those who are eligible to join a union, whether or not they have exercised that power to join such. Those are the unionizable employees. And in many cases, these are the cadre of employees that a union would wish to be recognized to. Non-unionizable are those who we are saying are excluded from joining the union. So those in any event are non-unionizable, they are not eligible. Then the unionized are those who have now, among the unionizable, they have decided to join a union. And therefore them, they are already unionized. So the unionized is that class of the unionizable employees that have now exercised their right to join a union. And as we go on, you will see how different in terms of what they pay in union dues, because that has also been key to understanding the whole aspect of industrial relations. If an employee or someone is employed to train all the above categories of positions, you cannot be a trainer or a manager if you are not one. Under 6, if you are a personal secretary to any of the managers, let's again take it generally. If you are a personal secretary or a PA to a general manager, then in the spirit of industrial relations, you are excluded from joining the union. Most also importantly is, and again, this has come up in many CBAs CBAs and recognition agreements is an employee who handles confidential matters. And again, this is dependent on different roles. Like for instance, if you have a driver to the CEO, definitely this is a person who knows a lot of confidential information, locations, a lot of communications in the car, whether on phone and so on and so forth, the meetings. And that again is excluded under the industrial relations charter. The union should not recruit this kind of a person for obvious reason that managers may need to sit and agree on some decisions that may not be very popular to the union, and therefore it will negate the purpose if the person doing the typing of that letter, if the person who is driving this manager is in the union, because ultimately that advantage will be lost as the union will get to know about this in real sense. And the Industrial Relations Charter also left these the prayers that it is not the list we have said of those who may be excluded is not exclusive, and therefore it is possible that parties to a recognition agreement can actually sit together and do agree to exclude some category of employees from the union. Remember, the keyword we started with is that any issues, any disputes should be dealt with in good faith and through a mutual agreement. It means it will be your job as the employer to discuss this with the union and agree which categories or cadres of employees should be excluded from being unionized and therefore represented by the union. Gap that you have noticed in our years practicing as IR practitioners is employers have actually, by design or default, lost their negotiating power in terms of what is in a recognition agreement. In many cases, once the union has attained simple majority, you will realize the union will be very fast to draft a recognition agreement and send it to the employer. And this may be a critical point where you now lose out on your argument or an opportunity for mutual agreement. Because once the recognition agreement is signed, then it goes without saying the next will be a CBA, and therefore you will find yourself discussing about who should be covered by that CBA when the train has already left the station. The question of who should benefit from the CBA should have been discussed at the recognition agreement level before the signature, so that parties will have agreed that this and that, this clerk is essential service cannot join, this level of drivers is okay, they can join, but at another level, these drivers cannot. So I would wish that underscored, and especially for those who still do not have the recognition agreement in place, but where the union is actively recruiting. There should be more emphasis in discussing and negotiating the terms of a recognition agreement so that you avoid discussing this when a CBA has been signed and so on and so forth. A lot of these recognition agreements are borrowed from the drafts and also richly from the Industrial Relations Charter. But in many cases, I've found situations where the union sneak in or delete some aspect, and therefore you find yourself, like for instance, the generality of this of describing those who are excluded. In many cases, where you would exclude managerial, supervisory, and confidential staff, because you may not list all of them. So you'll find, but then the union is usually uncomfortable with that. They just want you to exclude managers And once they exclude managers, you see, for them, they will tell you supervisors are not managers. And like you said, supervisors are classified differently based on different work setup. So we have to be keen by the time we are negotiating that document that we refer to as the recognition agreement or the RA. Just to emphasize, it is the employer that recognizes the union to represent a given cadre of its staff. Of late, you found situations where even an agreement could be limited to a certain section or a certain sector of operations of a company. Like, for instance, in the agriculture, you have found situation where you will find Kenya plantation representing an aspect of employees within a company who carry out a bit of maybe rearing of animals. But the same company, other than rearing of animals, would also have operations which include food processing. So you realize in this case, there is an overlap of the two sectors, one being agriculture, the other being food processing. It's possible that you can have a recognition agreement specifically for those players in the food processing, and one that is for the agriculture. So other than the sector, there is also which employees are you? Am I, as the employer, recognizing you to represent? And therefore, as indicated earlier, you need to list each of them and agree upon to avoid it in the future. Now, we all know the process of a recognition agreement, but I would wish to highlight quickly the journey that gets to a recognition, or where, at what point the recognition agreement should be signed. You realize the Constitution of Kenya provides for freedom of association, and therefore your employees have a right to join a union of their choice. The Labor Relations Act provides for a threshold, and again, I would want to emphasize that because it has been a source of confusion for many practitioners. But once an employee subscribes to the union, you will be served with what is called a Form S, or otherwise referred to as a checkoff form. Once the same is given to you, is actually a ministerial order that requires you to deduct and remit the union dues to an account that will be published in that Form S. And that deduction and remission has to be made 30 days from the date that you get the recognition agreement. I mean that you get the Form S, failure to which constitutes an offense. The only exception to that is if the union has not recruited more than 5. And I want to be clear on that. This is not a condition. There's one is a condition for you to deduct the payroll, and the other one is a condition for you to recognize a union. So the only condition set out by law is that if the union has not recruited more than 5, then you're not obligated to effect Form S, which is a deduction through your payroll, but the union can be paid directly by the employees. But where the union has recruited 50 plus 1, we talk of a simple majority. Then, and in this case, you know, this discussion about simple majority, 50 plus 1 as opposed to 51% has kept on coming. But the law provides of simple, meaning is a 50 plus 1. Once it has attained that, then by the law, the union can approach you as an employer, in this case now seeking that you sign a recognition agreement. And we'll look at the effect of such recognition agreement as we proceed with our presentation. In this case, so many disputes, disagreement has come up, and validly so, because recognition agreement is directly a product of numbers. And therefore, a difference of 1 or 2 employees would be the difference between signing a recognition agreement and consequently a CBA or not. You'll find in many cases, employers would be working to ensure the numbers does not hit the simple majority. While on the other hand, the union equally has been accused of using unorthodox means of enlisting people who are not even employees, sometimes repeating the name, sometimes signing for them, and all these kind of things. I'm sure these are things you're familiar with. And this is why the arbiters, mainly the Ministry of Labor and even the Employment Court, whenever there is a dispute about recognition agreement, it is always sent back to the ground, and you have, if necessary, do a head count, just to see how many of employees have willingly enlisted themselves to a union. And therefore, we have to watch that. Of course, an employer has an interest also to ensure that the persons indicators there are bona fide employees, and also that they were not enlisted against their will, because freedom of association denotes both the right to join a union or the right to choose not to join a union. So employees should not be coerced by the union, whether through threats, whether through induced false hopes to just enlist for the purpose of getting into a CBA, or for the purpose of the union just attaining the simple majority. So those have been the disputes. We'll also enlist a different angle under Section 56 of the Labor Relations Act, which provides for another level of recognition. And this is where employers or a group of employers are allowed to collectively come together and recognize a union. Let me still use the same word, collectively. I'll give an example. For instance, in a sector that I work with, like the flower sector, instead, which is in the agricultural sector, and correspondingly, which means the right union that is registered there is Kenya Plantation Agricultural Workers Union, and another one that was recently registered, which is Kenya Floriculture and Horticulture Workers Union. Instead of each individual flower farm signing a recognition agreement with the plantation, which would mean over 100 CBAs touching on the same sector, more or less the same terms and conditions, around 75 of the flower farms have come in together and jointly recognized plantation union through their association, which in this case is the Agricultural Employers Association. So I wanted you to understand these two tiers of a recognition agreement could be direct between an employer and a union, or the employers can come in together and bring in their peers and jointly negotiate the one recognition agreement and one CBA that works for all the employees. In case of a collective kind of a CBA and recognition, like I have alluded to, then the aspect of the simple majority will be simple majority of all employees collectively employed by the employers who have formed themselves together as a group. Remember, like again to illustrate, a flower farm could be having 1,000 employees. That's one flower farm. So a simple majority could be 501. And in this case, they would have to do a recognition and subsequently a CBA. But in a case where these flower farms have joined themselves together into 75 flower farms, collectively employing over 50,000 employees, then if the union wishes to have a recognition agreement with this group of employers, then it must recruit 25,000 plus one employee out of those employed by those employers' organization, so that it gets a recognition agreement. So that has to be clearly understood, that that is a right that has been granted by the employers, by the government, but in many cases, many employers have not collectively joined together so that they have that strong bargaining power with the union and have agreed to be sidelined and sometimes overpowered by sometimes unreasonable demands of the union, which they could easily have stood up had they formed also themselves in an employer's organization or group of employers. And the recognition in this case means, or the effect or the import of a recognition agreement is now the employer has established formal means of engagement. Remember, before then, a union could come and meet your people wherever outside the gate during the night and all that. So now the recognition now establishes formal relationship between the employer and the trade union, which now means the employer can write directly to you, seeking to come to the farm, seeking to come to do recruitment, seeking to come and set up shop for committee. So now this is now formally captured. And that's why I said it is important as we are doing this, you ensure that that recognition agreement is not hurriedly signed so that you're able to put in conditions, maybe for the activities of the union and the communications and so on and so forth. What I would also wish that we underscore, and this has been quite a challenge, especially for those who really do not appreciate the import or the effect of a recognition agreement, is that the moment you as an employer, you have recognized a union, then you should know that you have given up your right to discuss and negotiate with your employees directly. And this is key, and I want to give an example of what was happening during the peak of COVID-19, maybe the inception when a lot of adjustment at workplace had to be done. You could find a situation where an employer who has signed a recognition agreement with a trade union and consequently even have a CBA in force decides to bypass a union or the union and proceeds to discuss variations of the terms and conditions of employees directly with the workforce. That clearly violates the recognition agreement. And the danger of that is that as long as a recognition agreement subsists, if, for instance, you bypass the union and agreed on salary cuts with your employees, then the same can be challenged tomorrow because you have no mandate. You lost that capacity to speak directly to your people on matters, negotiations of terms and conditions, the moment you recognized the union. And in many cases, the terms of the recognition is that you'll have accorded the union the sole rights to represent your employees. And once again, you will have given this union their sole right. So there is no other body that can come in to represent the employees in a company that has a recognition agreement in a trade union. Now, if a certain union has come in and recruited, tomorrow sends you a recognition agreement. Again, before you rush to negotiate or sign, then you must ask yourself, is it the right union? And there's no one time that this question has been more pronounced than now in the dispensation of the new constitution. Because on one side, the constitution says every worker has a right to join the union. But here what we are saying, we have no issue with a worker's right to join a union. Our issue is which union? For instance, will you have a Kenya Nurses Union come and recruit your workers in construction industry? Clearly, that may not ever have been the intention of the constitution. The intention was you have a right to join a union, but it has to be a correct union. So today, for instance, if you're not in construction, and this has happened, and you find a union of construction which comes, recruits your people, and sends to you Form S requiring you to sign a recognition, it is okay for the employer to ask them that you are not the right union. I am in the agricultural sector. I am not in the business of constructing. We have had cases simply because you have a small lab there. The union of chemical union called Chemical Workers Union comes in and joins and puts your 1 or 2 lab technicians. So again, there must always be a question of you need to be the right union that can now play in my industry. Because remember, the terms that these unions will be negotiating is very different based on different sectors. Like for instance, if you look at the wages in the agricultural sector, they are very different from the wages in the generalized sector, which comprises all other sectors other than agricultural sector. And therefore, before you recognize, you should know that you recognize the wrong union. You should know that it will recruit based on the terms of the sector that this union is registered to operate. You must always satisfy yourself that the spirit of industrial relations charter is to avoid disputes, not to cause disputes. So in situations where there is already a union that is representing your workers, and then another union comes in seeking to represent the same employees, that becomes a recipe for industrial unrest, and a recipe for disputes, competing interests, and actually ends up achieving the negative, which is being the one that precipitates industrial unrest. So the unions have their own mechanism of solving their disputes whenever they overlap in a certain sector. And if it's not an issue for them to go back either to the ministry or to the employment court if one of the union is deemed to be encroaching on the other unions, and ultimately the courts all such labor disputes clearly see which among the 2 unions is encroaching, and therefore give a direction to the employer on which union they should work with. I've already said the issue of simple majority, so I don't need to re-emphasize on or repeat on that. The other document in industrial relations that I know is key is the CBA. I know the reason CBA is so present in our minds is that it's a document that is usually negotiated every other 2 years. And therefore, every HR would be very well familiar on the CBA, unlike a recognition agreement, which may have been signed before you joined and may never be revisited again. And this is a direct product of recognition of a union, and therefore the union now comes in seeking to improve the terms as enjoyed by the union members, whether directly with an employer or in a group setup, as I have explained before. And in many cases, renegotiated after a period of every 2 years. in some cases, and especially in the COVID situation, we have had cases where parties have actually agreed maybe to extend or maybe to vary the terms of that CBA. But it is important to underscore what I said earlier about the effect of a recognition agreement. At the moment you recognize this trade union, then you lost the power to negotiate or bargain. And therefore, if there is anything to be bargained, it will be done collectively by the trade union through a document referred to as a CBA. And once this CBA is negotiated, it has to be taken through the economic department of the Ministry of Labor to just ensure that whatever has been agreed there does not in any way violate the law. Remember, you cannot discuss or negotiate a CBA that provides for lesser terms than those provided for under the Employment Act or other wages orders. That's why it has to go through scrutiny to just ensure, like for instance, you not say that your employees will be having or will be enjoying 20 days in annual leave and not 21 minimum as provided by the Employment Act. So that's what will be scrutinized, and if the ministry is convinced that the CBA is progressive and within the law, the CBA is sent to the Employment and Labor Relations Court, where it is registered. Once it is registered, it becomes law, a superior law to your contracts of employment. It becomes a superior law to your HR manuals and policies, because now it has now taken another forceful level. It is now not only a document between the company and its employees, but also one that is acceded to by the Ministry of Labor and the Employment and Labor Relations Court. Many of you may have negotiated the CBAs, and this is where skills of practitioners in industrial relations are put to test. And it borrows heavily from the industrial relations data. Mutual negotiation in good faith between the players is supposed to be signed by the principals of both the employer and the union. So if your chief executive is in the name of the CEO or in the name of the MD or the director or so, whichever designation, then a CBA should be signed by the person who has the highest responsibility in a company, and on behalf of the union by the person who bears the highest responsibility in the union, in this case, the General Secretary of the union. I said it has to be registered in court, and the court has powers to either register it in the way it is submitted, or if there is any areas that violates the law, then it can be registered albeit with amendments thereof. And as you are aware, what is the purpose of this CBA? The purpose is to ensure the terms and conditions of employment are now not left to the discretion of the employer, because without a CBA, the employer will decide when and how much to increase on any of the terms of employees. When the CBA comes in place, then it will set the periods within which the CBA will be registered. It will keep reviewing, and the reviews will be as a product of engagement between them. The CBA also borrows from the recognition agreement, in that it is also going to have resolution mechanisms that should help employers and employees come to a faster resolution of any dispute they may have, and more or less also creates industrial harmony to the extent that the players, being the employees and the employers, know that periodically they sit together, and not in a forceful manner, because this is what the union always would wish to go and tell its people. They would want to take all the credit. That if you got a new 10%, you see your employer was refusing, you do that, we call that bad faith, because a CBA is an agreement. If you fail to reach an agreement, your only recourse will now be to go to court or to report a trade dispute. And where you're not able to agree, then there will be other mechanisms put in place. Like for instance, where you have not agreed on the percentage. Okay. Then if it goes to court, each party may be required to provide proof. The union will, of course, claim the company is doing very well. The company will also have documents to show maybe how badly the business has been affected. And on the basis of such, the experts in economics are the ones who advises the court on what is the most reasonable percentage that will ensure the employees' interests are taken care of, but also that does not kill or paralyzes the business of the employer. Yeah, and since, like I've said, this is a document that now has a higher force than what the employer may or may not have been doing before a CBA comes into place. It is now predictable because, you know, unless in very unusual circumstances, improving with every cycle that it is negotiated. It will also help the employer to be very clear about budgeting, because you can be able to have a reasonable trajectory of where the next CBA is likely to push the cost of the employer to, and therefore they're able to plan and make their proper forecasts. As I've said, a CBA is binding, has a binding effect. It ranks higher than your contract of employment, because like you said, in this case, where the CBA provides for the minimums, then the policy cannot again take them away, neither can a contract of employment. So provided it is for employees who are covered by the CBA, and those that we're calling unionizable employees. Yeah. And we have explained the terms unionizable employees, and not again belabor so much on it, unless there are questions which I'll handle after I finish with the first part of this presentation. And there is a requirement that once you have this CBA, it now dictates what will now be in your other documents, which I've alluded to, the policies, contracts for the unionizable employees, so that it becomes the minimum. Yeah? There is a requirement that if a contract, for instance, if contracts that you issue to your employees refer to a CBA, which many would do that because they really do not want to replicate a whole CBA in the name of a contract of employment, then the contract in many cases will just be referring to as per the CBA in force, as per the CBA in force. Now, if you do that, then there is a duty that the CBA needs to be displayed in a conspicuous place that is frequently visited by employees, and it should be trained on the employees properly, so that in the event you may need to use it or refer to it, an employee does not play the ignorant card. It will also codify any other staffs and regulations that you may have had before. It will equally import some aspect of labor laws just to make sure it is more emphatic. Like for instance, it's not unusual to find CBAs importing part to do with BIBA, medical treatment, disciplinary processes, summary dismissals and all that. So it will bring them to a way that they are better understood to employees who may not even have access to these other to the elaborate labor laws. It becomes easier to be sure that have been trained and they are aware of what the law requires of them. Inside the contracts of employment, before the CBA, most likely you had most of the terms and conditions in the contracts of employment. Now with the CBA, it's more or less a one-stop shop that is actually now used to guide the contracts of employment. Before a CBA comes into place, you might find so many customs and practices are not codified, and this has been quite challenged. And a good example is like, for instance, you'll find a company that periodically pays some form of gratuity at the end of every year. But if you try asking the company where that has been codified, you will not find it. When a CBA comes in place, then it will now codify that as a term. And therefore, once it comes to the CBA, now you have to negotiate whatever initially employees were calling service or gratuity or miaka yangu or whatever, asante, comes with. So at that point, what it tells you is that it was a custom, but they could not lay their hand on what it is called, and if it is disputed, it becomes difficult for you. This is of benefit both to the employees and to the employer to have very clear terms under which the parties to a contract of employment work. Court awards have said it is court awards, like I've said, forms, we call it judicial precedents. Yeah, judicial precedents, and also a lot of these forms basis of industrial relations, whether in practice, whether in codifying into the CBAs, but more or less for clarity purpose. I started by introducing Article 36 of the Constitution, and that is about freedom of association. I don't need to force this, only to add something that has kept coming up about the workers' right to exit from a union. This right is usually discussed in a very selective manner in favor of the unions. And they're saying the right to join a union means employees must be in the union. We have had to intervene and deal with cases where employers get non-compliances with the market audits simply because there is no union. And whenever such a case comes to me, we have been very clear to interpret to whoever is raising that question, that unless they can demonstrate that the employer has in any way refused the union to come to the firm for recruitment or any other reason, then employees have a right to choose not to be in the union. And therefore, if they so choose, that is also freedom of association, having exercised their right not to join. And not only limited not to join, but also limited, also extended to withdrawing from such union. Again, the Labor Relations Act is very clear. Should an employee wish to exit or resign from the union, then the only thing they need to do is write to the employer. And I want to emphasize that because it has come up severally. Write to the employer, and upon receipt of that resignation letter from your employee, then you should cease such deduction 30 days after you have received it. Your only duty as the employer is to ensure that that letter is copied to the union. And there is a very big difference because we have had cases where the union makes it very difficult for employees to resign by providing that the employees must write this resignation, go and look for the union wherever their offices could be, and the union would then in effect frustrate this employee's right to withdraw. There is no requirement for the employee to look for the union. The requirement is for the employee to look at that or for that person who is deducting their money. Because remember, Section 19 of the Employment Act is very clear about instances when you can effect deduction from an employee's salary. And one of them is where an employee, either through a CBA, through the law, through a collective bargaining, through a court order, has actually, or even through writing directly to you, has authorized you to deduct. And the same employee has the right to come and instruct you. Remember, it is his or her money. They have a right to come and tell you, kutoka mwisho hii mwezi ama kutoka saa hizi nimetoka kwa union and I don't want you to deduct my money. From that point on, remember the authority has been withdrawn from you. And if you continue doing that, you do that at the risk of refunding this money to this employee if they complain, as they would certainly do. And yeah, that is still emphasized by the Constitution, shall not be compelled. So again, do not allow the narrative where the union comes and have the employees fight against each other. And especially when they are trying to look for the simple majority, it's very easy for some of the employees to be classified as the sellouts, as the traitors, as those who are the stumbling block to a CBA. So you should not allow any of that to happen. Somebody should come and give the advantages of joining the union, and employees should be given a right to choose if they want to be or not be in that union. And remember, again, we concentrate so much on the workers' right, but if you look at the same Constitution, it actually provides for registration of employers' association, so that it also gives meaning to the employers' right also to unionize or to join themselves into associations, and therefore be able to have that bargaining power against or to tame any aggression that may come from the union. We have Section 41, again, which are sources of industrial relations. And remember, all these really contribute to fair industrial relation practice or harmony at workplace. And whenever there is friction or wherever there is an employer who wishes to, or who is inclined to stiffen or restrict any of the rights of an employee as provided for by Article 41, then that becomes a recipe for industrial unrest. Every person has a right to fair labor practice. Those who have been watching what has been going on in court will bear me witness that this is one of the animals to watch now, because this is not about what is written in the CBA. This is not about what is prescribed anywhere. This is what is deemed to be fair using the lens of the court. So whatever it is you're doing may be within the law, but if the effect of the same is that it refers to what can be unfair labor practice, then you have a problem. And if you look at the wordings of Article 41, they are actually umbrella, and they are left to interpretation to whichever habitat that you might find yourself having to habitate between you and your workers. So the first is fair labor practice. The other one, they have right to fair remuneration. And I'm not sure if I asked you what is fair remuneration, I'm not sure you can get a consistent answer, but that's the way the Constitution puts it. So again, when you're setting this to ensure they are not recipes for industrial relations, it's always good to compare with what your peers are paying, because this is what can always bring rise to a claim of that an employee was not fairly treated. A reasonable working condition. Yes, reasonable working condition can be interpreted in so many ways. And this is conditions which is devoid of bullying, devoid of unsafe work environment, devoid of discrimination, and so on and so forth. So it is so wide, so much so that if an employee is claiming that they feel that the condition at workplace is not good because of either or any other parameters that you may have or that is imported to the law by the law, including the laws on disability, then you realize that under this provision of the Constitution, then the employee can always later on, other than claims for unfair termination, can also say they are right as your employee or violated because you did not provide fair labor practice under Article 41. We alluded to the right to form, then participate in activities of a union. That is a right conferred by the Constitution, and therefore you cannot take action. I'm sure this is well known. You cannot take action against an employee for either forming, joining, or participating in the activities of a trade union. This is usually very pronounced, and especially when you take up legal action against an employee, against your shop floor representative, against your shop steward, because whenever it goes to court, then it becomes a question of whether what you did was targeted to frustrate his right for participation in activities of a trade union, and therefore you realize you always start at a losing end, where you have taken disciplinary action against a shop floor representative who will always argue that they were targeted because of championing the interest of the employees. We have discussed the right to go on strike. Allow me not to repeat that. But also, other than the Constitution of Kenya, always be guided that there are other international labor organization conventions that have been signed into and ratified by the Republic of Kenya. So as a practitioner in HR industrial relations, kindly familiarize yourself with now fair labor practice as discussed and explained further under the ILO Convention number 29 of 1964. When we allude to the freedom of association, again, make sure you familiarize yourself with the freedom of association as it is understood internationally, and more so under the ILO Convention number 98. And if you're talking about collective bargaining, also be able or be sure that you have downloaded and familiarized yourself with these conventions, which are ready downloads on these websites for these international, for the ILO conventions. Equal remuneration for work of equal value. Again, look at ILO Convention number 100. This has been quite an issue, including when we are audited by international market labels. And in this case, the question has always been, how is it that one worker who is doing the same job have a difference in salaries of up to 10,000 shillings? Some will explain that it is due to the many years they have worked, but ideally the principle is, are they doing the same kind of a job, the same kind number of hours? Then if that is the case and they live in the same country, the same economic challenges, what would be the explanation given for having them remunerated differently? So again, let's familiarize ourselves with ILO Convention 100 of 2001. About forced labor, I'm sure that is not so much now. We have already moved from that. Yes, the country or the Republic of Kenya ratified that in 2001. And most of these ratification in the early 2000 is what led to the amendment of the labor laws later on in 2007, just to domesticate these principles in our laws. But of course, they are not put in the same details as they are in the documents, that is the ILO conventions. In the next few, because I know we have discussed generally, I will look at the role of the government in IR, and this I just give sweeping statements because I'm going to share these slides. And this is to ensure we have proper laws, regulations to enable an environment for dispute resolution. This is meant mainly to be done through the Minister of Labor. I begin to hear whether the government has got well in this, but ideally, that's one of the key roles of the government. If you look at the provisions of the labor relations, it actually provides for a threshold of 30 days under which any industrial dispute should be resolved. And it is in the principle of ensuring a speed resolution of disputes. You are aware, the Minister of Labor offers conciliation services between the employers and their unions. If necessary, the Labor Department has the right to come and ensure that employers carry out fair labor practice within the law, and this is through the inspection services. Through the Register of Trade Union, that is also under the ministry, they employ the players in industrial relations, that is unions and the employers association, the federations and confederation of trade unions are all registered by the Register of Trade Unions. Ensure the formulation of policies that are meant to spur economic growth in the interest of all players, so that on one hand, as the employer is being asked to negotiate more, then the employer also needs a conducive environment that should enable them to pay more to the trade unions and their members. Management of strikes and lockouts, yes, whenever there is a strike and lockout, then the first call is the Minister of Labor, who should come very quickly and seek to speedily resolve that kind of strikes. Creation of jobs, again, I don't need to read all that, but ideally, the role of the government is to ensure that you have reasonable conditions that ensures that the labor and each party to the industrial relations are able to have a conducive environment to work in. Key is also the setting up of what you call minimum conditions of employment, and mainly through the wages councils, that every labor day give a framework of how salaries and other terms would be reviewed. And this gives guidelines on how the unions and employers, especially in negotiating the CBA, stand guided. And a good example is during this year due to COVID, when the government did not announce any changes, which in itself sends a signal to all the other players that the economy is not doing well and therefore should be reasonable in the demand that they may have. As the employer, we have said the key word here, ensure there is no discrimination, or rather you give an environment that is not hostile to workforce, avoid unlabor fair practice, yeah. Embrace dialogue by talking to your workers and talking to your unions constantly to ensure there is no spillovers from the workplace that could lead to adverse industrial relations. Have a motivated workforce, and generally, like I said, ensure that you exercise fair labor practice. The role of trade unions, you will again tell me whether they have succeeded in doing this as envisaged under the Industrial Relations Charter. is, of course, negotiate. You should always, at the back of your mind, know it is the work of the union to negotiate for good terms, for better terms. So when they're asking for the 60%, do not look at them in that manner. What you need to do is give a reasonable response to the same. You should know they will not mind the 60%, and therefore becomes your duty to show that your company cannot afford a 60%, and hopefully then you'll be able to settle at a 10% and so on and so forth. So you should know it is their role to do that. Voting members, they have that statutory duty under the Labor Relations Act to access the workplaces for purposes of recruitment. Remember, this they do whether they have a recognition agreement or not. The union have a right of access to your firm. And the only condition set out under the Labor Relations Act is they have to come at a time that is conducive, and they have to give a reasonable notice to the company for planning purpose. Otherwise, if you refuse them to access, then they can go to court and get a court order and come and access the workplace forcefully using the same order. It is their job to ensure they safeguard employment, and this is where the keyword we said here is mutuality, because the union should appreciate that if there is no employer, then there is no members by extension. Of course, lobbying about changes of the law where they find maybe it is obsolete or they need to borrow good practice, then that's part of their role. Representing their members. You know, representation is key. Representation is statutory, especially in cases of disciplinary cases. Representation will start when an employee is being heard during disciplinary hearing, but it also goes all the way if the matter goes to the labor office, or if it proceeds to industrial court as it was, then it's now the Employment and Labor Relations Act. The union has a right to appear as advocates for their members. Of course, they have a right to educate their people. They have a right to discourage employees from agitating and carrying out union activities during working hours. They have a duty to ensure that their members follow laid down procedures and regulations. Sometimes this is in contrast when you find the union defending employees who are clearly on the road, but under the spirit of the charter, the union should actually encourage their members to follow the law, procedures, CBA, and so on and so forth. And this is why in many cases they will ask to come and train their people, but sometimes you don't allow them, but you should know this is part of their role as envisaged as players in the industrial relations. And this is what is listed there under number 8. They should discourage them from being negligent at workplace. Anything that may damage the property of the employer, carelessness, insubordination, etc. Ideally, it is their job to ensure employers also follow the laws as set by the land, including those that are imported by the recognition agreement, the CBAs, and any other rules and regulation. Of course, they also have representation at higher levels. In this case, it's not unusual for us to hear the principal in the union movement having to travel every other now and then to Geneva, where the headquarters of the ILO is seated. And in this case, they'll be sitting their capacity representing the workers in Kenya, sometimes Africa, and any other region. They will be convened and discuss that. To cap up and just the highlight keys of why it is important, or it was important for us to go through industrial relations, is to know that when you have an effective industrial relations at workplace, then some of the ingredients are very key. And the first one is you appreciate the partnership role between management and the union. And this has quite been sticking for many HR practitioners or companies that their representative actually treat the union as adversaries. We have had, I was dealing with a case where an employer actually deployed dogs on a union branch who had come in to recruit and represent an employee. So that is against the spirit. You must appreciate that they have a legal right to exist and represent. And therefore, what you need to do is engage them within the law, but most importantly, appreciate that they are actually an extension of HR management. In this case, those who have been in this for long knows that at every one time you should have the number of your branch or representative of the union, because like you said, this is an extension of the HR, and if you block it, then it is a recipe for industrial relation staff in the future. Again, you cannot have good IR where you have policies that violate the law. So again, for IR to thrive, can you ensure that you are founded, that your company is founded on sound labor practice, best legal and HR practices at the firm? Because then it becomes easier when in the presence of the union, you're able to demonstrate that you're an employer who follows the law. That boosts industrial relations. Where there are issues, constant negotiations, consultations, communication is key. So this is why I said you should have among the speed dials the number of your union guy, because he's likely the first contact of an employee from your company that may be complaining. So if you have got that constant discussions, communications, most likely you're able to sort that thing over the phone and it doesn't flow over into collective grievances and or industrial unrest. Agree, all of you, to follow the channels as put down by the recognition agreement and in the other channels. So for instance, if the requirement for a strike is to give a 7 days notice and try to have it arbitrated before you call in for a strike, of course, the ingredient is that the union should actually issue that notice. And you as an employer should not be cornered by that notice. Actually, you should know that many unions that do not follow will just ask their people to just withdraw labor, which is what you're saying is wrong. But if they decide to follow the right channel and give you a strike notice, employment should take it in good faith, because that 7 days notice is meant to give room for the dialogue. But you have found in many cases, once you issued with a strike notice, then immediately you have either parties have to run to court. And by doing so, instead of sitting to discuss whatever the issues is or are with a view of resolving them, you find there's a lot of twisting, and that's why you found in some cases the CBAs have piled up for 6-7 years, because the parties are more engaged in fighting out there than in handling grievances, talking, consultations, and negotiation. Key also for effective IR is having a trained management. And I'm glad that today is part of what makes us qualified to be such trained management, to appreciate the different angles of industrial relations, because that tells you how that union guy will be received at the gate or at the boardroom, depending on how knowledgeable the HR manager and by extension management are aware about the need to have good engagement with the union other than combative one. And this is also a challenge also to the union to have equally well-trained and knowledgeable union officials, because this has been a major complaint from most of the employers, where you really find you have a union that sometimes is very impossible to discuss with or to agree with. So it's key that they're also trained, because from a trained perspective, you can have a very good dialogue and either agree or disagree in a civil manner. And if you have disagreed, agree to take that dispute to the next level in a civil manner without resulting to strikes and all that. And if you look at what would be the obvious outcomes of a proper and effective IR, is a good working environment, a workforce that is motivated, more or less a culture that is based on negotiation of issues, is give and take. Looking for a situation where you don't have the winner takes it all, it's a win-win outcome. The union wanted 60%, you wanted 0, but you're able to agree on a 10 or 15% for a year or 2 years, so that each of the party feels that each other moved to a position that made them mutually comfortable. At this point, Paul, I would wish to pause at that and see whether you can be able to take a number of questions from that presentation. Paul?
Thank you, Peter. We have taken us through a lot of detail, right from recognition agreements, grievance handling document, tripartism, talked about the CBA, talked about fair labor practices. You've talked about the role of the ministry and everything else that I've not mentioned. There is a question from one of us who prefers to call himself or herself anonymous. And the question is just simple: how do you handle disagreements in a civil manner, but within a procedural format? I'm not sure whether you've understood. Yeah.
You handle
disagreements.
Yes.
How to handle disagreements in a civil manner,
yes,
but within a procedural format. I know you've not gone into the details of grievance handling, but I think you can pick up the question now.
Yeah, I will attempt to answer that, and I do agree that it is not always that it is envisaged that you will agree in any dispute that involves the union and you as an employer. But if you look at most of our agreements that we have, whether the grievance handling, whether the CBA, whether the recognition, all of them have an exit. And an exit means that we have not been able to agree on this, and therefore the agreement or recognition provides that we now escalate it from the shop floor to the branch level. We have not agreed at that point, then it can be presented to the top executives of the union. In some cases, and in most CBAs, they actually provide that if you have not gotten as a solution in a bipartite environment, that is you and the union, you bring in a third-party player in industrial relations, which is the government, and therefore you go in more or less a trade dispute. Again, you engage in good faith. Remember, in all this, I'm actually not saying that either of the parties to push unreasonably on their agendas to the exclusion or the other. We are not saying that you have a shouting match at any one point. In fact, in industrial relations, there is no room for that. And if you go to the labor office, again, the law is very clear about what you should be able to do in a labor office. Again, the engagement for those who have been there is also civil, and for a good conciliator, they will also listen, they will also try to negotiate, they will look for a middle ground. And then the law still provides for another forum where if the conciliator gives their recommendation and you're also not agreeable to it, the Labor Relations Act is very clear that the same advice is not binding, and any party aggrieved by the recommendation of the Labor Office can appeal to or can proceed to the Employment and Labor Relations Court for further arbitration. And even from the ERRC, the matter can go all the way to the appeal, which in any event now means that there is a logical escalation of any issues that you're not able to agree, but there is room for discussions that are very civil, that are very procedural. And this part of what I alluded to, that in the beginning, as you sign in the recognition agreement and so on and so forth, you should commit bound by the rules and regulations that you have put in place. So it is, I would answer that it is very possible that you negotiate. If you're not agreeable, even at the firm level, you usually sign what you call a certificate of disagreement. Again, it's a very civil document where you'll be saying, we have not agreed on the percentage increment, and we are willing to have a third party come and help us. So that's a civil disagreement that you can both sign over a cup of tea and not let that other player assist in doing the same. So yeah, it is possible so long as both of the players, being the union and the employer, are committed to respect the avenues, mechanisms, and offices that have been put in place to help them reach a conclusion in the event of such a disagreement. Yes, Paul.
Thanks, Peter. And you have addressed the issue of the right to join unions. But I have my senior here, Mr. Masese, who is asking whether Article 41 of the Constitution poses some contradiction to the Industrial Relations Charter, whereby the Industrial Relations Charter limits who is to join the union, but the article provides freedom to join the union. I know you've talked about this, but maybe just one or two more points to put more clarity to it.
Thank you so much, Paul, and I'm glad that my learned colleague in this industry is also on board. And yes. My take on the same is initially and prior to the Constitution, the promulgation of the Constitution around the year 2010, these labor rights were not entrenched in our Bill of Rights in the Constitution, and therefore they were enjoyed subject to the statutory limitations that were put in place on the enjoyment. Unfortunately, and that's what I had keyed in, is that the moment Article 41 came in clearly providing for a right of every employee to join a union, or every worker to join a union, it actually in a way rubbished the protections that were put in, especially under the Labor Relations Act, to the extent that it provided for procedures for these strikes. It even excluded some categories of employees, especially in the essential service, from going on strike. And essential service more or less also included the civil service, and therefore it was unheard of prior to that for some of these essential service to either join unions or even participate in strike. So I would say, yes, that drew out the fabric as he had known. That was the spirit founded by the industry players to the industrial relations. But while on the same, I am glad to note that most of the cases that have gone through our courts, either challenging on whether it is okay to exclude some level of employees from joining the union and whether it should be the same union, then I am glad that the courts have kept guiding players. And that way, we are actually in a way going back to those restrictions that still there are some procedures you must exhaust before exercising your rights to Article 1. That would be my take. That would be my take. That In fact, even if you were to look at what happened around 2010, that's when we had almost everybody, the whole country going on strike. But with the time, that is becoming managed progressively.
So can an employee waive their right to join a union?
Waive means, can they decide not to?
Yes, I mean, say, okay, fine, I am an employee of this company and recognizing that my duties involve A, B, C, D, I agree that I cannot be a member of the union and therefore I'm waiving my right. Will it be unconstitutional if it's done without, if he's not forced to do that?
Okay, I look at it in two ways.
Yeah.
First of all, the freedom of association the freedom of association, as I understand it, denotes the right to either join a union or not, and therefore I would not say an employee has to give an excuse why they do not want to join. I would more focus on where an employee is maybe on promotion, actually told that note this, you have been promoted from job group this to this, and you're now told note that this is not a unionizable position and therefore not entitled to join a union, blah, blah, blah. And now this is where you're saying about that line, about when you can be, what is that line where you can be required to be excluded from being unionized to the non-unionizable cadre. And on that basis, I've said with time, the courts have guided that it is okay to exclude some caliber of employees from unionization. And therefore that can be put in as a condition to the extent that the employer also requires a cadre of employees that should speak on its behalf. And in that case, yes, it will be conditional that you have to give up your right to join the union if you want to serve as a manager in my company. That is something I would say can be done, and you may need as an employee to direct consent to that. That would be my take on that question.
Thank you. Quickly, let's move to the last two because of time. Agoy Achok, I would like to know whether parties can engage in CBA negotiations without a recognition agreement just because there is a union.
Thank you for that. I would say that would be premature. The escalation in law is very clear that you need to have a recognition agreement to be able to negotiate a collective bargaining agreement. So you have no mandate. You could call it any other document, but they will not, in the strict definition of the law, qualify to be called a CBA. And in any event, it can always be challenged on very many accounts if indeed it did not follow the right escalation before the negotiation of the same. Like you said, the recognition actually sets up the framework for engagement, including defining which is the cadre of employees that are going to be covered by the CBA that will be midwifed after the recognition agreement. So I would say that is premature and will not in any way be encouraged or legally anchored.
And perhaps the last two is from Haron. He says, owing to the fact that all employee negotiations must be through the union, what happens with negotiations and terms of employees who have not joined the union?
If I got your question well, is that negotiation in a unionizable
for employees in the union, for the employees who've joined the union, they are done through the union. Yeah. So he's asking, what about those who have not joined the union? I guess it's a situation. Yeah,
that's a good one. First of all, you appreciate the law outlaws discrimination on the basis of unionism or membership to a union. And that's the reason in a CBA environment, you have always found that once a union negotiates a CBA, then this CBA will be applied to all unionizable employees. It is not only applied to those who have elected to join the union. And this is also what brings in the other aspect that I may not have alluded to, that is referred to as the agency fee. Because in this case, those who are not in the union will still have their terms and conditions negotiated by the union, and they will benefit equally like those who have joined the union, but they will have by operation of law to pay agency fees, which in a way is supposed to which in a way respects their rights not to join the union, but also ensures that there is no discrimination at our workplace, and that the union that negotiates that CBA is equally funded to continue doing the same. Yes,
okay.
That would be my input on that.
And Dr. Jojo Oko here says that he wants you to explain the nature of industrial relations in private sector where staff are fired at will. They are also not allowed to form unions. George, huku ni wapi bana?
Na kama ni yangu ataacha kuifanya. Nini uko na mimba, umepoteza mama. Utafanyaje? Itabidi ukae hapo. Kwa sababu utaenda.
Mike, can you mute the speaker? Yeah.
Sorry about that.
Okay. Yeah. Peter, we are back to you. George is talking about a situation where, yes.
Yes, I had a situation where you're saying people are sacked right, left, and center, and the laws.
And they're not allowed to form unions.
The legal framework as it is does not allow that sacking right, left, and center without following the law, because there is no specific laws for employees in public or private sector. So that's a violation, and it should be addressed through the legal mechanism that has a remedy of anyone who is terminated or dismissed without following the provisions of the law. About not following, forming the trade unions, like you said, with the new constitution, that is Article 41, then the right to restrict someone from joining or forming a union is more or less coming or progressively becoming a thing of the past. The only question you should ask is maybe whether you're joining the relevant union, whether you are the right cadre to join such and such a union. But having looked at the landscape where you found now almost everyone who would have been deemed not to be able to form unions form, and that is even in the public sector, then I am not sure which is this private sector that can alienate itself and forbid people from joining the union. And if it did, is what qualifies as a typical violation of the Article 41, is both an unfair labor practice and an affront to the employees' rights to join and participate in activities of a trade union. And an employee can take action based on the violation of Article 41.
Okay, in the interest of time, I'd like you to address the concerns of a member here who's saying that they have a proposal that in the confectionery industry, they have received a union proposal, and they are worst hit by the pandemic, and they're not even in a position to give a single cent in the negotiations. How best can they go about it? Negotiation tactics.
Thank you for that. Yeah, thank you for that. Yeah, it is, some of these aspects now becomes economic issues, and that's why I had alluded to the Ministry of Labor being well placed to adjudicate any of such issues, because indeed, if it is true that the employer's ability to pay, which is a key factor in negotiation, has been compromised by the pandemic, then it is among the reasons that you found through the tripartite discussions, especially last year in the height of COVID-19, the FKE, COTU, and the ministry were actually able to come up with MOUs that included implementation of the CBAs, negotiating CBAs, and all that. So I want to believe it is also a case that should be addressed, first of all, in good faith, negotiated, and if the same is not agreed upon, then each of the parties can submit to the next level of conciliation, where each of them will be able to present its position. And indeed, it is true, many companies are not able to give anything, but it's also true that it's not overall. There are still companies that are still solvent enough to give increment even around this time. So it has to be dealt with a case-to-case basis. It has to be issues of evidence and giving information to either party and the conciliator if it has to get there. Thank you.
Okay. Peter, the final questions before you can move to the next phase is a comment from Andrew Masese that of late advocates have been suing outsourced outfits and enjoining companies. Is that procedural? The next question is talking about how do you compute agency fees for employees that enjoy benefits from a negotiation CBA? And the last one is, can you ask for dissolution of a union as an employer when the numbers fall below the minimum requirement? I hope you can remember the three, or you can go one by one.
Why the trend
enjoyment? Yes, the first one is about enjoining companies where advocates have sued the outsourced outfits.
Yeah, yes, it is both a factor of ignorance and the reality, because ideally, in many outsourcing outfit, most employees, by their level of understanding, will know that they work in company X because indeed they work at its premises. And therefore, definitely the employer in this kind of a situation is an interested party. Yeah, because remember, it is the employer that has engaged the outsourcing or the manpower company to provide his employees on certain terms. So ultimately, even in court, the terms of that umbrella commercial agreement definitely comes into play. And that's why I'm saying I would not be surprised. But if indeed it is a clear case of outsourced within the legal framework that governs outsourcing in Kenya, then indeed the employer can put in a defense that this was not my employee, because indeed the supplier or the manpower supplier is the employee who will now be liable for whatever cause of action the employee will be looking for in the court. But remember, there are some aspects that still cuts across in terms of responsibility to both the outsourcing and the employer, for instance. And in a case that you're looking at is where a case at point is on occupational safety or work injury, where I'm not sure in the spirit of the act it allows you to outsource safety at the workplace. It is still be on the occupier. So there are all those variables, could be ignorance, could be the fact that the employer is an interested party, could be in a case where even if provided for by the outsourced company, the employer is still responsible, and especially on the aspect of safety. I hope that is answered well. On the issue of agency
fees, yeah.
Yes, if you could refresh what the issue was, it how it is computed?
How it is computed?
Yes, it is usually equivalent to what employees would be paying the union dues. For instance, in plantation sector, the union dues to KPAW is at 2% of the basic, and that is equally what is paid to as agency fees, if I'm not wrong. It's a percentage, but it varies from union to union, so it's good to check on the form S and the agency fee as it is agreed. There should be formula. The union should be able to guide you on the formula for levying of the agency fees upon following the legal mechanism that are allowed before before such dues becomes payable by force of law. The other one is dissolution.
Can you ask for, can an employer ask for dissolution of union representation when the numbers fall below the minimum requirement?
I would use a different term, and this term is the recognition, not dissolution. Because dissolution in a way means, dissolution may mean that it is completely deregistered.
Yes.
Other entities where it has now. The recognition is a process. It's not an easy process. And yes, it is possible. It is envisaged that a union should have substantial representation for it to get both legal and moral authority to speak on behalf of all the other employees who may not be its members. And what is provided for by the law is for presentation of such application for dissolution to the National Labor Board. And once it has been heard, then this labor board can allow the employer whose union membership has gone significantly low to recognize that union. But of course, I would say it's not an easy process, considering that the same players would be interested, including COTU, would be among those who sits in the National Labor Board. And even its constitution over the years has been quite a challenge. But yes, it is an avenue that is provided for by the law. The other avenue would be to go through the courts. Yeah, but it is possible, but not easy.
Okay. Thank you. Can an organization have ex-employees as union representatives? I guess, yes, somebody left, but is still a shop steward.
No.
Is it possible?
No, a shop steward should be an employee, an active
employee.
Yes.
But a union, a branch representative can be an ex-employee.
Exactly. A branch, now that's a different level of union. They can be an employee or elected as a branch.
Thank you, Peter. I think we have gone through all the questions that I've been able to spot. Thank you for those who have asked. And if you have not had an answer to your question, just maybe raise up, give me a shout out. We have 30 minutes to 5. And I know we have an obligation to complete this on time. I don't know, Peter, what you still have in store for us and whether we can be able to clear in the next 15 minutes.
I wouldn't be
sure
we can be able to conclude, but I would gladly share a slides in terms of grievance handling. But
yes,
then because the other aspect was just grievance handling. So I will share the slides, but I will not need, I will share to you for sharing to the participants. But ideally, I could just give a brief, in a few minutes, just about what the subject of grievance handling entails, and patch it up.
Go ahead.
With what, we patch it up with what you have already discussed. But ideally, the way we understand a grievance is that it is that sense of injustice against the employer, either maybe from a certain employee or generally due to the terms and conditions there. So we'll call it is a sense of injustice. And this sense of injustice may be true or may even be imaginary. And true means it could be maybe a violation of 1 or 2, 3 things that may be codified somewhere, which you can actually lay your hand on and seek to redress. But also it can be imaginary, and we have had cases where companies have had to rise and deal with imaginary grievances. And I remember the other day, possibly could just share to just understand what we mean an imaginary grievance is where in a company that I was consulting for, a production manager is promoted to the position of a GM, and within a few months buys a big car. And around the same time, there are some few employees who actually dies out of very unrelated causes. But the one that goes around the whole company is that this GM is actually sacrificing the employees to whatever those other imaginary forces. But needless to say, by the time you get to come to the farm, is that everyone is on strike, that you see at Atumaliza. So it is a grievance that may not be true, but indeed that is there. The key points to dealing with grievance is a grievance should never be ignored. I think those should be the key takeaways that we need to have at the back of our mind. A grievance should be resolved as quickly as possible. And most importantly, a grievance should not be confused or mixed with disciplinary issue. So as much as a discipline issue could be a grievance, for instance, where a certain manager chooses to address every other small issue, warning letters, and so many papers that employees have to fill right, left, and center, so that you find them they are aggrieved about the administration of this disciplinary procedure, or maybe about how fairly that disciplinary procedure is being administered, being favoring to some people, aspect of sexual harassment, tribalism, nepotism, and all that, which all could sum up as grievances from the workers. It should be distinguished from discipline itself, aspect of discipline, so that we are not, as managers, keen to go and punish something that ought to have been a grievance and that ought to have been resolved through disciplinary procedures. And from the many of the consultations that we've had coming in and out, yes, that has been the main confusion. For something that ought to have been sat down, addressed, and dealt with at a very preliminary level, it ends up piling up, and then ultimately it will explode into a bigger industrial action out of a build-up. In our experience resolving strikes, whenever we present or the usual procedure that I know most of you also apply whenever there is a standoff, you will want to get a small team that you will then ask them to give you the grievances that could have led to the work stoppage. And you can agree with me that they will always list a whole foolscap and even turn over and continue listing. But if you ask me, it will only be one of those grievances that would have now exploded into an industrial action. Otherwise, you'll find the usual, the use of abusive language, the targets, the disciplinary execution of disciplinary process, and they will even bring in the issue of salaries and all that. So they keep piling up. So the key that I would wish to share with them is there should be a mechanism at the workplace that allows grievances to be dealt with at the lowest possible level in that grievance handling system. And I would want to believe this would be at the supervisor's level and their shop floor representative for that particular department. And therefore this underscores, and maybe perhaps it was important to bring it up at this during this presentation, is that this also touches on recognition of the union. Because you really find that there is a lot of push and shove about who is the bigger one between the shop floor representative and the supervisor. Instead of them recognizing, like you said, the general spirit of recognition agreement, instead of them recognizing that each each of them has a legal mandate to represent a certain constituent at that level, then you find there is a lot of power play where the supervisor would want to be seen as the bigger one, and at the same time, the supervisor would want to prove a point, and therefore an opportunity to resolve a very basic grievance is missed. It keeps piling to the next level, next level, next level. Also important for me to highlight generally is about a company also that commits to its grievance handling system. Because in many companies, you will find a situation, for instance, where there is an elaborate and well-coded grievance handling system. But you will find on the management side themselves, they will wish to keep short-circuiting the grievance handling at will. And therefore, the whole workforce loses the meaning of the grievance handling system. Or where, for instance, when a supervisor is at the ground where maybe a misunderstanding has happened, and instead of escalating it to the next level without personal investment in it, you find that they follow it up with a very personalized agenda, which includes that they want this person to go because they may have threatened or because they are going against what they would have thought as the best way forward at their level. And therefore, with time, employees lose interest with the internal grievance handling process. And what then happens is that the first call for reporting of what ought to have been grievance becomes now the union at the branch level, becomes the labor office, and at the moment, as we know, nothing even stops it from going and becoming a labor or a court matter. So generally, I'll just cap it by we respect the institutions and the procedures that have been put in place. We respect the fact that employees have a right to grieve and air their grievance, and such grievance must be resolved. It cannot be ignored, whether real, like I said, or whether imaginary. That cumulatively added with the principles we have discussed about good industrial relations would ensure that there are lesser and lesser grievances to be dealt with at the workplace. Allow me to stop at that. Like I said, I will share the slides on grievance handling so that in the interest of time, if there are any questions that were particular to that, I could take. As you also
thank you. Thank you. Quite a number of questions have come in. Just to go straight to Flora Silong. Of course, she's asking, can an employee in management position be a private contributor and member to a union? I know you've touched on that, but just give her the clarity that she needs.
Yes, I would say yes. An employee has a right to contribute directly to the union. And therefore,
in managerial, an employee in managerial.
Now, I would say they will contribute because, like you're saying, it's being done offline, not through payroll. So yeah. I am assuming maybe at the point where the union wishes to represent is when they tell you that this person was contributing to a union. But the key word here is your recognition agreement to the extent that it excludes that manager from being represented by the union. Then your argument at that point is that you shouldn't even entertain that union to discuss anything on account of a person it is not recognized to represent. But you cannot stop somebody from sending their money where they want to.
Okay. And Perpetua Murage asks that she has some seasonal employees terminated due to reduction in demand for their services, and these employees have joined the union after the termination or after the end of the contract. What are the repercussions?
Thank you for that. It's a question that will always defeat the employer, and therefore, if a situation like that comes, it's not about when an employee joined the union, for the reasons that have been alluded earlier. these employees have a right to join the union and contribute directly. And that's the argument the union will pull on you. And they will ask you, how do you know when they became members? And you see, that will be a stalemate on you as an employer, because they could have been contributing for a year before they were declared redundant. So for me, the advice there is, don't go there to the fact that they were not members. Just deal with the issues that they are raising with the same union, if it is the right union, and see whether you can get away out on the same.
But Peter, suppose you had the evidence that they joined after. What happens? Does it render the membership inconsequential to the employer?
I'm just trying to think through what would be the evidence you have, because this is the card that has always been used in many of the cases I've tried to discuss. Because the will tells you, and the union has a way of even backdating those membership cards.
You're right.
So they defeat. You try using that angle, but they will just come all of them with the green cards. We have always been members, and they will even escalate it further and say why we have not been giving the names to you is because we knew you'd sack us. You see, that changes the whole dynamic.
Yeah. They play victim.
Exactly. So the best is, let's look at the grievances, see whether we can stem them at that particular moment, whether directly or with the union, because otherwise they will just escalate and those arguments will not hold water forever. At some point, you still have to deal with what the issue these employees have, whether them canvassing them directly or through these unions.
Thank you. Patrick Mayo has introduced an issue that I wanted to bring forth because it's a hot topic in the country currently, the relationship between TSC and NAT, and whether TSC is right to discriminate against NAT members and, in fact, to withhold contributions or to stop deductions for NAT members. Is simply asking, is TSC breaking the law?
I would have my reservations to that, because it has been something that has been going on for a while, and so many disputes and all that. But indeed, I would say this is a product of what I alluded to, that the union must appreciate that the employer is the owner of capital, and that the union views that anything that comes through the deduction to the employees is a direct product of the employer existing in the first place. And this is a typical case of a breakdown of this relationship that we are discussing today. That you have a union which is pushing. You have a union which is refusing to even agree to any progressive way, to any progressive measures to improve performance and all that. You have a union that always resorts to strike action instead of dialogue. And therefore, the employer in this case decides to also pull their card. And one of the card is, I must not deduct on your account. If you ask me where there are violations, I would say there are quite some violations. But then again, it's the government.
What about discrimination here? There's an element of discrimination, that these are two teachers doing the same job. One is a member of NAT, another one is not a member. They're not getting the same treatment from the employer.
This is what we discuss. Because clearly,
just in very short, in a straightforward way, without necessarily looking at the case of TSC in detail, but just looking at it from.
In fact, I was to start even looking at the ILO convention, which Kenya is a signatory to, and Kenya is the employer here. You're talking of equal remuneration for equal of the same value being done by people here. So these are two high school teachers, one being paid higher because they don't belong to this union and belong to that other. I would say that would instead stand the test of time if challenged. And yes, it would amount to discrimination on the basis of unionization.
Yeah. Okay. I think most of the questions are just repetitions. Can an employee be deducted union dues by virtue of the company recognizing the union? I guess the employee has to join the union first and give consent. Am I right?
Yes.
Unions are there to defend employees. Why do they at times compromise with employers at the expense of the aggrieved employee? That is from Nancy Kahi.
Yeah, it's an interesting one, but then this is outside the law. If some union guy comes and get some boozy so that they accept 1%, I would not say that is within the legal framework. I would say they're abdicating on their role to ensure that the employees who elected them are taken care of. But then you see it takes two to tango, because in this case, it will also be an employer who will be inducing the union to take something in exchange of a lower percentage or something. So it is in bad faith, it is corruption.
And we as representatives of employers should be able to shun that practice.
Exactly.
Okay. I think we may not be able to exhaust all the questions. But let's look at when you are a part-timer in university, can you join a union? I think a part-timer is an employee, isn't it?
I would say so. I think it's if you are once again, let me say it may borrow so much also because that university has a recognition agreement with whatever union is representing the employees there. So could we start look at what does that recognition talk about? If it excludes the part-timers for some reason, then maybe reason for exclusion. But if the part-timers you're saying is an employee who qualifies as a unionizable employees in that university, there is no reason or legal reason why they should not join a union.
And Dorothy is asking, I worked for a firm where employees were deducted agency fee and had not joined the union. Is this legal?
It's legal if there was a CBA in place that these employees were enjoying.
Are enjoying.
Even if they had
Absolutely.
not joined the union, but there was a CBA they were enjoying, yes.
Okay. Thank you very much. In the interest of time, and I know people are keen to leave their workplaces at exactly 5, I would want to draw this to a close and promise that the slides I received from you will share with everybody, because grievance management is also a very important area that we needed to exhaust. I think this is an exciting topic. It's normally more of a practical topic than what you read in the books. I think the more you practice employee relations, the more you get to know it, the more you get grounded. So for many of us, I think we've learned quite a lot from Peter. And if you have any questions that you still want to ask, you can still post them. I'll put my email there, and you can direct whatever questions that you still have. I'll direct them to Peter, and Peter will be able to assist you. And unless anybody wants to say something, I'm opening the floor to anybody who wants to make a comment. I'm reminded that we had a problem with muting and unmuting, but I know some of us are able to unmute themselves. Peter, would you want to make a closing remark?
Just to say thank you once again for considering me to share with your team, and just to confirm I'll be available if there is anyone who may have particularized areas that we may not have covered and wish to consult further. In the slide that I'll give you, there is my contact both on email and phone. And once again, thank you so much for also listening to me.
Thank you, Peter. On behalf of Mount Kenya South, the officials and the members, on behalf of IHRM, thank you for all the members who listened to this, who have been with us for the last 3 hours. Mount Kenya South always strives to bring topics and interactions that have immediate benefit to the members. And we look forward to hosting you again in the next session, which will come in the month of July or August. So thank you very much, and may you all have a nice evening. Peter Kinyanjui, thank you. Thank you, thank you, thank you. You've always been available and readily willing to assist us. We have no way of saying asante sana. May God bless you so much.
Asante sana.
Asanteni na kwaherini.